Paper 2, Polity. So in General Studies 2, there are 3 units in General Studies 2: Polity, Governance and International Relations. By seeing the trend of the previous papers, the stress by the examiner is on the applied part of polity and on the governance aspect. So if you take a standard paper of 250 marks, the textual, the polity part, the static part may get you just about 40 to 45 marks. The bulk of the marks is on the applied part of polity, that is the governance, and around 50 marks is on the international relations part. So today's question for discussion is: the Supreme Court's action in reviving the Collegium can be seen as an act of judicial overreach. Critically examine in the light of the various judgments of the Supreme Court in this regard. Answer in 150 words. So, how do we analyze this particular question? This particular question, what we have to do is an introductory part on what the framers of the Constitution or the founding fathers, what were their views on the relationship between the 3 organs of government, that is the legislature, executive and judiciary. The main part of the answer will be you highlight the different judgments of the Supreme Court, then emergence of the Collegium. Then the third part of the answer will be how has the Collegium worked. So this will be the framework for the answer. First you come to the introductory part. The introductory part, it will take around just 2 sentences. So the founding fathers of the Constitution did not want any one agency of the government to become powerful at the cost of the other: the legislature, executive and judiciary. So we copied the system, the framework from the British Constitution. So what happens is there is a system of checks and balances. The founding fathers did not, I repeat, did not want any primacy to any one agency or wing of the government. See, the Constitution envisaged consultation. In appointment of the judges, the President of India had a dominant role. He would consult the senior-most the judge of the Supreme Court, who is the CJI, in appointment of other judges. Similarly, consultation through the CJI with the concerned High Court and for appointment of judges of the High Courts. So this consultation, this process is envisaged in the Constitution, that the President will make the appointments in consultation with the Chief Justice of India. Now gradually later on what happens, there is a series of judgments of the Supreme Court. The first judge's case agreed that the executive had a dominant role to play in the process of appointment, that is primacy of the executive. The judiciary agreed with the view expressed by the founding fathers and by the framers of the Constitution that the President had a dominant role, that is the executive had a dominant role in making judicial appointments. So this system worked for some time. Now gradually what happened was, in the second judge's case, the judiciary took upon the view that consultation with the Chief Justice meant concurrence of the Chief Justice. So when a proposal was submitted for the opinion of the Chief Justice, the judiciary took the view that consultation means concurrence and the judiciary had to concur, had to give its consent. So you see gradually how the judiciary was gradually encroaching, starting the process of judicial overreach. In the third judge's case in 1993 on a presidential reference, the Supreme Court held that, okay, concurrence of the Chief Justice means concurrence of the Chief Justice with the senior most judges. So here they brought in the concept of Chief Justice of India plus 4 senior most judges. They called it Collegium, which will play a dominant role in examining the proposals relating to appointment and transfers. So you must remember that the word collegium is not mentioned anywhere in the constitution. The word collegium has been coined by the judiciary, and in the third judge's case, the concept of collegium emerged, and the stand taken by the Supreme Court was all appointments, all transfers shall be done no doubt by the President, but with the consultation of the Chief Justice and 4 senior judges in this regard. So, and in the fourth judge's case, the Supreme Court came to the view that collegium is part of the basic structure of the Constitution. Why this fourth judge's case came about was, say, government had brought about the National Judicial Appointments Commission to streamline the process of judicial appointments, and the NJAC, good deal of drafting, public, it was put in the domain, the opinion of experts was taken, then the NJAC was passed by Parliament, got the approval of the President, and half of the states ratified it. I mean, it took such a long process. The Supreme Court struck down the National Judicial Appointments Commission by saying that the whole thing, the NJAC, was unconstitutional, and now they declared that collegium is part of the basic structure and it cannot be amended. So collegium remains. Now, when you see the working of the collegium, see, basically before you go to working of the collegium, the first important thing which we should understand is India is the only country where the judges appoint themselves. The system is not there anywhere in the world. So you take the functioning of the civil service. You take the civil service, for instance. There are different levels in appointment. The Public Service Commission appoints him after conducting an exam, then it interviews him, determines the selection. Then another agency, the government, interferes on behalf of the governor or the president, issues the appointment order. Then again, the third agency, the deputy commissioner, and gives training to the probationer posted in a district. Then next, again, there's another agency in the government which declares the probationary period. So what I'm trying to stress is that at every level there is transparency. Here, the collegium, this is the only agency where the judges appoint themselves, and what has happened is the first defect in the working of the collegium is lack of transparency. You might have seen in the social media and in other places how lack of transparency has led to nepotism, wherein the advocate in a high court, because his links with the collegium in the Supreme Court, automatically becomes a Supreme Court judge. From the High Court, he gets elevated to the Supreme Court only because of his connections. So nepotism is the major bane of this system. In fact, one of the senior judges of the Supreme Court, who was overruled, she describes the collegium as a thief's kitchen, in the sense that nobody knows what is cooking. The whole thing is very shrouded in mystery, and there is lack of transparency. The second thing which I would like to point out in the working of the collegium, see, this system of collegium, it is not there in the Constitution. It is not mentioned anywhere in the Constitution. It is a system evolved by the judiciary for the sake of the judiciary. Then you come to the disputes between the government and the judiciary. See, now if you see the latest, from April 23rd, the collegium has not met from April 20th up to date. and there are nearly 120 proposals pending in the Collegium. So why is it that the Collegium is not able to decide? Obviously because there is the memorandum of procedure has not been formulated, and in fact government has suggested so many times to the Supreme Court to evolve a procedure which in consultation with the government. Somehow the memorandum of procedure, it has not been streamlined, lot of delays are happening, and this is further contributing to the delays in deciding cases, coupled with the shortfall of judges, coupled with the lack of infrastructure, whatever. So the second point which we noted in the working of the Collegium is there is no unanimity in the memorandum of procedure. In the answer, what you can suggest is you can quote the practice prevailing in UK. You have the Judicial Appointments Commission, which comprises the judges, prominent citizens, administrators. So this body screens the applicants and recommends who can be appointed as a judge. You can mention the thing saying that since the Collegium has not delivered the results it was supposed to, the way out would be to adopt a procedure like the system prevailing in UK. So summing up this particular question, first you start with the introduction of 2 lines on what the framers of the Constitution envisaged. Obviously, they did not want one branch of government overriding the other. Then you mention the 4 judges case. So this will be about, you are going to write for 150 words, that is 15 lines. About 6 to 7 lines you write on the judgments of the Supreme Court. You need not go into details. Just mention what it is about, the basics. Then working of the Collegium, you write about 6-7 lines on sentences. You write about the actual working of the Collegium. You explain what are the drawbacks in the system of Collegium. Finally, you conclude your answer by suggesting the best practices, what can be adopted. You give the example of the Judicial Appointments Commission prevailing in UK. I think that will sum up the answer.